Okay, we're ready. I'd like to welcome everybody. I'm Bruce Thompson. I'm chair of the Water Quality Control Commission. This is our meeting of March 12th. And we've got an agenda. I think it's been circulated. And the first item on the agenda is a roll call. So I think Ms. Corral is going to do the roll call.
Yes, good morning. Vice Chair Armstrong.
Present.
Members Reddington.
Present.
Member Cavallari. Member Dominguez.
Here.
Member Frank.
Here.
Member McWilliams.
Here.
Member Valentino.
Yeah.
Member Captain is absent today. Member Rosato.
Here.
Chair Thompson.
Here.
Member Velasquez. Member Michelle.
Here.
Member Symphony.
Here.
We have a quorum.
Okay, thank you. So the second item on our agenda is approval of the agenda. I assume everybody's had a chance to look at it. Any comments, questions, modifications? If there are none, I'd entertain a motion to approve it.
Fair enough motion.
Second. Council, does this have to be a roll call vote since we're all present? Sorry. Okay, so we're going to do a voice vote. All in favor of approving the agenda, say aye.
Aye.
Opposed? Thank you. Next item on the agenda is the January 9th minutes. The minutes of the January 9th meeting. And those were sent out about a week ago, so I hope everybody's had a chance to look at them.
Chair, I just note that on the top it says this was virtual.
I think you were.
No, it was virtual. It was virtual because of inclement weather. Right.
Okay. Again, I'm looking for a motion to approve the minutes of the virtual meeting of January 9th.
Mr. Chair, I move to approve the minutes as submitted.
Fair enough second.
Okay, moved and seconded. Comments? Ready to vote? All in favor of approving the minutes of the meeting of January 9th, 2024, say aye.
Aye.
Opposed? Okay. Next item, set aside, is public comments. Just go, do you have any people that request to make public comments?
I haven't had anyone, nor do I see anyone that's indicating they want to make general public comments.
Okay. Last chance. All right, let's go on. Agenda item number 5 is WQCC 23-76, approval of the final draft of the 303B 305B integrated list of assessment service forms.
Good morning. Good morning. Good morning, Chair Thompson and members of the commission. My name is Crystal Weatherly. I am Assistant General Counsel for the New Mexico Environment Department, and I'm here representing the Surface Water Quality Bureau in this matter. With me, I have Meredith Ziegler, who is the Clean Water Act 303D, 305B Assessment Coordinator. To my left is Heidi Henderson, the TMDL and Team Supervisor. And hiding in the back is Shelley Lemon, our Surface Water Quality Bureau Chief. On November 1st, 2023, the Bureau filed a petition with this commission for the approval of the final draft State of New Mexico Clean Water Act, Section 303D, 305B integrated list of assessed surface waters, also known simply as the integrated list. The integrated list is Appendix A of the 2024-2026 Clean Water Act 303D, 305B integrated report. The integrated report and its appendices are required under, you guessed it, Section 303D, 305B, and 3 of the Federal Clean Water Act. Section 305B of the Clean Water Act requires states to submit the integrated list to the Environmental Protection Agency no later than April 1st every other year, including this year. The Bureau is here to request that the Commission hear their presentation on the integrated list and for the Commission to approve the integrated list so that the Bureau may submit it to EPA by that April 1st deadline. And with that, I'm going to hand it over to Ms. Ziegler to provide the presentation.
Thanks, Crystal. Good morning, Chair Johnson and Commissioners. As Crystal mentioned, my name is Meredith Ziegler. I am the Assessment Coordinator at the Surface Water Quality Bureau. I am here today to ask for approval of the 2024-2026 State of New Mexico 303D, 305B integrated list. This integrated list is Appendix A of the integrated report and includes both the 303D list of compared surface water and a list of assessed waters. This presentation and the draft order were emailed to the administrator on February 23rd of this year, and the order and associated documents are available on the WQCC.
Are you ready for the speaker slide? Okay.
Yes. I'll just give you a thumbs up.
Okay.
To set the stage for today's presentation, here's a quick review of the Clean Water Act framework the Bureau operates under. The Bureau collects water quality data and determines the water bodies receiving and designated uses listed in the Clean Water Standards in a process called assessment. Determining whether or not the water quality goals detailed in 20.6.4 NMAC to be achieved for specified water bodies or 3 regions referred to as assessment unit or AUs. And in this presentation is the primary objective of the development of the list, which is Appendix A. The integrated list informs the problem-solving part of the framework. Specifically, the Bureau develops TMDL and watershed-based plans that then inform NPDES permit certification to address point sources and the implementation of best management practices to address non-point sources. These next two slides provide a more detailed explanation of the integrated list and why we are presenting it to the Commission today. The integrated list is a state's list of assessed surface waters. The term 303D list or list is the state's list of impaired waters. For example, stream or river segments and lakes that are impaired. The list is designed to satisfy the statutory requirements of Sections 303D of the Federal Clean Water, the Federal Water Pollution Control Act, commonly known as the Clean Water. It is submitted to EPA for approval every even numbered year on April 1st, or by April 1st. For each water on the list, the state identifies the pollutant causing impairment when known and assigns priority to the development of a total maximum daily load, or TMDL. The list of associated documents are available on our website as shown in the figure to the right. Under the New Mexico Water Quality Act, the Water Quality Control Commission, WPCC, is the water pollution control agency for all purposes of the Clean Water Act in New Mexico. A state water pollution control agency means the state agency designated by the governor having responsibility for enforcing state laws relating to the abatement of pollution. Per 33 U.S.C. 1362. The New Mexico Environment Department is the primary constituent agency responsible for administering and enforcing all programs implemented by the state under the Clean Water Act. NMPD is also the principal source of technical expertise to the WPCC for Clean Water Act actions and activities. Under the Clean Water Act Section 303D, states must develop and submit a list of impaired waters to EPA for EPA approval. EPA approves or disapproves the state's 303D list of impaired waters meeting MDLs. The integrated list or 303D list is incorporated by reference into the New Mexico Water Quality Management Plan and Continuing Planning Process, also known as the WQMP CPP. At Section 3. This figure shows the watersheds in Mexico, which were the primary focus of this particular listing and assessment. The Bureau completed a 2-year water survey in the Little Colorado, Rio Verde, Rio San Jose, Jemez, Southern High Plains, and Lower Pecos River watersheds during the years 2021 and 2022. There were additional sources of data recycled, and they included EPA, USGS, and flood data collected on state waters, downloaded from the Water Quality Portal, San Juan River Basin multi-jurisdictional monitoring program data, Service Water Quality Bureau effectiveness monitoring data, data for various stream regions in and around Taos and Point River submitted by Davis Ramos, Anthony Water and Sanitation District anti-degradation data, San Water Soil and Water Conservation District Clean Water Act Section 604B grant submitted data, and Los Alamos National Laboratory and NMED DOE oversight bureau data downloaded from Intellis New Mexico data. The associated external data quality determinations are available on our integrated report. The integrated list, or Appendix A of the integrated report, contains the Bureau's assessment conclusions and documents surface water quality designated to sustainment by an individual assessment unit. Specifically, the integrated list contains the designated use of payment status for each assessment unit based on most recent WQCC and an EPA approved version of 20.6.4 available at the time of assessment, and assess using the procedures described in the Bureau's current comprehensive assessment and listing method, referred to as the COMP. It also includes AU, or assessment unit, and parameter, or impairment cause, integrated reporting categories 1 through 5, based on the Bureau's column and EPA's integrated report. New Mexico's list of impaired waters, for the Clean Water Act 303D list, is specifically all higher category 5 waters in the Appendix A list. And that is the focus of EPA version 6. The integrated list contains information on 872 assessment units, which breaks down to 686 stream and river regions, 173 lakes and reservoirs, and 13 watershed basin. An overall AU category has been determined for each assessment unit, as well as each identified impairment parameter within each. These next two slides describe the various integrated reporting categories. Category 1 and 2 waters have been monitored and are meeting Clean Water Act goals. Category 3 is assigned when we have no or not enough data to make an assessment. The Bureau created a set of categories within IR Category 3 to help with survey planning to fill those data. Category 4 is assigned to impaired waters, TMPLs, or other pollution control requirements in place, or if the impairment is due to pollution as defined by EPA, as opposed to a specific pollutant. EPA considered IR Category 5 waters to be New Mexico's official Clean Water Act 303D list. The three subcategories in IR Category 4 are official EPA products, while the subcategories in IR Category 5 are state defined and help the Bureau guide. It is important to note that Category 4 waters are also impaired, even though they are not technically on the 303D list. This slide summarizes the general timeline of the development of the 2024-2026 integrated list in relationship to the primary data sources and the public participation process. I will go over these components in additional detail in the upcoming slides. Please note that the primary source assessment data for any given listing cycle is the Bureau's previous 2-year rotational watershed survey. Therefore, the Bureau's monitoring schedule determines the focus of any given integrated cycle. Assessment unit determinations outside of these watershed survey areas remain largely unchanged, unless, for example, there is a source of outside data or an applicable water quality standard change between reporting cycles. Now I will guide you through the public participation process. The revised comprehensive assessment and listing methodology, also known as the CALM, combined with official data solicitation, went out for a 30-day public comment period on July 14th through through August 14th of 2023. EPA Region 6 also provided a review of our listing methodology at this time. Following this period, all accessible data was collated, UA'd, and verified, and assessed against the water quality standards. The draft 2024-2026 303D integrated list was released for a 45-day public comment period on December 11th, 2023 through January 24th of this year. During this time, EPA Region 6 provided additional review. It was posted to the Surface Water Quality Bureau website. An email announcement was sent out to Gov Delivery to over 2,000 recipients in both English and Spanish. And we received specific comment text from Buckman Direct Diversion Board and Anita Front. There were a few specific changes to the integrated list based on public comment received, as well as additional staff review. These are noted in Appendix C of the integrated report entitled Response to Comment. I've also provided a copy. The next two slides cover these changes. Specific editorial changes were revising the wording to the definition field of the integrated list to clarify that assessed date does not denote data collection dates, and removing the duplicate definition of assessed in the definition field. Other minor revisions and clarifications included reviewing assessment unit comments for consistency, removing out-of-date comments, such as comments referring to sampling conducted during previous monitoring rotation, removing anecdotal AU comments and inferring existing or designated uses to standards revision planning documents, and adding an AU comment indicating if an AU falls within a designated outstanding National Resource Water, or ONRW. As a result of these actions, there were minor revisions and clarifications to the associated assessment rationale, formerly referred to as ROC. A few more specific changes were made to the integrated list during the public comment period as a result of further staff. For Clearwater Lake and Demotto Lake, an impairment for mercury fish consumption advisory was added as a result of late data from the laboratory, and a new fish consumption advisory for these lakes. For Rio Fernando de Cows, the segment from Canditas Creek headwaters, temperature and specific conductance impairments were documented during the 2020 listing, and noted in the assessment records that admitted to a data entry and were added. Finally, the AU previously named Burns Lake and Rio Riva was renamed to Laguna del Combo to align with external references to water body. An AU comment was added to note the change, and the nutrients listing was changed from higher category 5A, 5B, to indicate that while still impaired, more data collection is needed. All public comments were carefully considered, and the extensive response to comments document was prepared, posted to our website, emailed to commenters prior to this meeting, and included an Appendix C of the integrated report. These next two slides provide summaries of information called an integrated list listing cycle. The summary graphic of designated use of payment status was generated using our data held in our internal database. Please note that all fish, culture, public water supply, and industrial water supply designated uses are defaulted to not assessed because no numeric criteria apply uniquely to these uses per 20.6.4.900A. This is a summary graphic of a designated use of attainment status by lake acreage in New Mexico. Again, please note that fish culture, public water supply, and industrial water supply designated uses are defaulted to not assessed because there are no numeric criteria that apply to these uses. This slide compares the top causes of impairment in streams and rivers in the cycle as opposed to last cycle. Note the differences on the x-axis, including increased coli, nutrients, aluminum, and specific conductance. Specific conductance overtook flow regime modification in the cycle, and temperature remains the leading cause. This slide compares the top causes of impairment in lakes and reservoirs for the cycle as opposed to last. Please note that the listings based on contaminants and fish tissue are based on fish consumption advisories. Elevated levels of chemical parameters in fish tissue are the result of bioaccumulation of aquatic food chain. NMED, the Department of Health, and New Mexico Department of Game and Fish collaborate on the development of fish consumption advisories. The advisories are posted on both the Bureau's website on the Fish Consumption Advisory webpage, as well as the New Mexico Department of Game and Fish's website under their legal and safety advisories in the subsection titled Catch Release. The final draft version of the integrated list, Appendix A, Appendix C, response to comments, and the supporting document were provided to the WPC administrator and posted to the Bureau's website on February 23rd. The availability of final documents was also announced via email to commenters prior to this meeting. The Bureau is requesting the Commission approve and incorporate the integrated list as proposed. In addition to the 360 list, states are required to submit Clean Water Act Section 305B water quality reports to EPA. The 305B report contains information on the water quality status of all waters in the state, and analysis of the extent to which the Clean Water Act Section 101A2 goal service the goal of surface water quality protection and propagation of fish, shellfish, wildlife, and recreation in and on the water is being achieved, an overview of the progress in water pollution control, and a description of the major non-point source pollution and programs for non-point pollution control. Given that the 303B report and the 303D list are due at the same time, April 1st of every even number year, EPA recommends that states combine them into a single integrated report, even though EPA only approves the 303 list. The next steps are provided here. If the WQCC approves an integrated list, then the NPD will submit the WQCC approved integrated list and associated certified B report, collectively known as integrated report, to EPA Region 6 electronically via EPA's Clean Computer. EPA determines whether the integrated list, Appendix A, meets the requirements of the Clean Water Act Section 303B. And when available, the final EPA approved integrated report will be posted to the NPD. I have provided the main integrated facts here. At this time, we are happy to take any questions from the commission.
Thank you, Mr. Questions? Well, I'll start. I note that, and this was not assessed in this cycle, but it was assessed 2 years ago. The Rio Grande Alameda to 550 Bridge is designated as a public water supply. It was, I believe, it was assessed. It was assessed in 2020. I'm sorry. Yes, it was assessed, but it was the region, the river was assessed, but the whether or not the river water quality attains the criteria established for public water supply says it's not assessed. And so I'm confused. I'm looking at page 222 of the agreement. Is my question clear?
Yes, Chair Thompson, thank you. You give me just a moment to pull up the list.
Sure.
You said 222?
It's page 222 of the integrated list, which is page 241 of the PDO.
Thank you.
All the other criteria, the livestock watering, mixed marginal warm water, aquatic life, those have a determination whether or not they attain their use. Public water supply does not. Since that is the water supply for 700,000 people, I thought that was interesting.
I believe, yes, Chair Thompson, your question is clear to me. I believe I did allude to this during my presentation. This is because public water supply designated use specifically does not have any numeric criteria in 20.6 except for 900A, and which is page 14 of the presentation. There are no specific numeric criteria against which to assess that designated use.
Okay, interesting. And does the department expect to bring numeric criteria to the water quality control commission? Seems like that's sort of an important use of water. Since I drink it.
Do you want to?
Yeah, Chair Thompson, that's a question for your team, and the water quality standards coordinator.
Chair Thompson, so do I need a microphone? Can people online hear me?
No one's indicating they can't.
I talk really loud, but I don't know if I talk loud. So, yeah, it's on. I'm trying not to be too loud. For public water supply, there are the Safe Drinking Water Act, which allows for that water to be filtered and delivered to the community that is being served. Those criteria are technically what is used to ensure that there's clean water for those systems. Public water supply means that it's managed by an organization to deliver water to a community. We also have domestic water supply, which is less less structured, and that does have criteria associated with it, but it still requires the water to be filtered in order for it to meet drinking water standards. So there are two sets of standards. We're not intending to have numeric criteria for public water supply, but we are indicating that the water is taken, delivered to a water treatment facility to go to the community that is being served, if that makes sense.
I understand. They're two different laws, though. One is the Clean Water Act and the other is the Drinking Water Act.
Right, and to ensure that the water that is being delivered to your home is safe, it's the Safe Drinking Water Act.
So should we even have a public water supply criteria in our surface water standards if we're never going to establish numeric criteria for them?
Chair Thompson, it's just a recognition that the water is a public water supply. It is a definition in NMAC, in 20,674 NMAC, and it's one of our designated uses. It does not have numeric criteria that apply. We do have general criteria in our water quality standards, but in order to assess, we need a number to evaluate how water is.
Okay, I'm going to have to think about that for a while. Thank you. Mr. Eckhart?
Sure. So I was looking at the areas of the state that you listed as your focus for this report, and I noticed, and it's probably true all through the list in the report, is that there are certain segments that are listed as not assessed. Is that just because it's difficult to find enough water to assess, or what is the issue with those segments?
Yes, Mr. Thompson and Commissioner Brayford, it's a really good question. You alluded to one of the many reasons why it could be that water body was not assessed. We do have a minimum number of data points that are required for assessment from the water body. Oftentimes it's a minimum of 4 data points that we require, so that we're not assessing just based on one data point. However, it could also be because the water body was dry, or we were unable to travel to that water body to assess or collect data for assessment in that specific watershed. There are some water bodies that are very, very difficult to reach and oftentimes don't have water enough.
I was looking specifically at the what some people refer to as the Rio Puerto of the West, which flows out of the Iranian mining country into right through downtown Gallup. There were certain segments of that were not assessed.
Yes, Commissioner Brayford. I used to be part of the monitoring team, and I can attest personally that oftentimes that section of the river is dry, and we were unable to stable many times because that section of the river.
So a totally different question. In this flow chart, what this leads to is the development of total maximum daily loads for these compared TMDLs. Where are we on the TMDLs? We didn't address the one for 2022. Is there one for 2023, or is there one coming up for 2024?
Chair Thompson, Commissioner Reinhardt. We've been continuing to develop TMDLs. We brought the Upper Rio Grande TMDL to the commission in 2022. And since then, we've continued to write TMDLs, take them out for public comment, receive public comment, respond to them, and then we've just been going until the commission is able to come to a decision about the role of their part of the process, the approval process.
Thank you. And not just the commission coming to the commission, but we do have the Court of Appeals review, and so we are waiting for a ruling from the court on TMDL before we move forward and whether or not they would require.
Well, and we're going to evaluate the issue of the statutory change, maybe related to this. I'm just curious as to how much of a backlog has there been. It's been about a year and a half since that 2022 decision by the commission.
I think I can speak to that.
Yes, so the TMDLs we released in 2023 for public comment were in the Gila watershed in the southwest part of the state and the lower Rio Grande. We will soon have some lake TMDLs out for public comment, and we have a couple other TMDL documents that are in staff development right now. So we do have EPA requirements for TMDL development, so we're continuing to develop TMDL.
Thank you.
So I would like to point out that we'll have a brief update on the status of the court case in agenda item 9. Okay. Other questions? All right, I've got one, and this is sort of, it's not germane to approval of this list, but under the new definition of waters of the U.S., many of the reaches in the assessment units will no longer be waters of the U.S., I'm assuming. They will be the ephemeral and perennial springs and sewers and things like that. So in future years, will this integrated list be reduced from 400 pages to something smaller?
Yes, Chair Thompson, that's an excellent question. We are aware of that potential issue. At this time, we are continuing to develop a list in the same way that we have. They are still state waters, and they are still impaired or assessed as state waters under our New Mexico water quality standards. So we will continue to operate under those state New Mexico water quality standards, and EPA may or may not take action on certain water bodies in future lists.
But the 303 list is a federal requirement. We don't have a similar state requirement.
Correct.
There are standards, but not the requirement for biennial reporting.
Yes, that is correct, Chair Thompson. There's a little bit of uncertainty as to how this will affect our process, but at this time we're continuing to follow the process, and we were directed by the Region 6 to continue as normal for now.
Commissioner Dominguez.
Thank you, Mr. Chair. This is a little bit of a general question, and it's an outcropping from some of the public comments and the department's responses to the public comments. And it centers around some of the ONRW segments, and that there were 6 segments, ONRW segments that were listed as impaired. And then I believe in your response there were 7 UAs on ONRWs that were delisted. So my question really is more, your answers were fine, understanding. My question centers around ONRWs and impairment. Given that ONRWs, when the commission approves those, they're brought to the commission as these are the premier waters in the state, the best of the best. And yet now we're seeing we have impairments of the best waters in the state, which gives me pause. And what's going through my mind is, are we having major impairment issues, or do we have segments designated as ONRWs that maybe don't fit the ONRW classifications? So I'll throw it out there. Whoever wants to take a stab at this can. I know it's not directly specific to the listings, but this catches my attention when we're having impairments of ONRWs. So it just gives me pause. So if someone wants to take a stab at that, I would.
Yes, Chair Thompson and Commissioner Dominguez, it's a really good question. I can take a stab at that. Those water bodies that I noted in the response to the comments, they were new parameter impairments, and I would note that those actually already had, all of them already had existing impairments. Some of them had TMDLs developed in place. There are some mechanisms for addressing impairments in ONRWs. For instance, we have an MOU, Memorandum of Understanding with the Forest Service about impairments and addressing degradation and impairments on Forest Service lands and waters. However, it's a really good point, and I hear what you're saying. I don't know if Shelley wants to add something further as far as the designation of ONRWs themselves. However,
I think Ms. Lemon was trying to hide over there next. So.
Chair Thompson, Commissioner Dominguez. ONRWs are waters that the state wants to establish more protections to protect. They may not be pristine, like there's different criteria for the ONRWs. It doesn't have to be pristine water quality. It could be a recreational or cultural or an ecological significance. So it is complicated because land use management comes into play, and we don't always have control or a say in that land use management. But like Meredith was saying, we are working with the Forest Service on Forest Service land to help better manage the land so that the water quality is better. We are using ONRW status in our 401 certification. So right now I have a 401 certification from New Mexico Department of Transportation, and they are required to have an individual permit for review and certification. They cannot use the nationwide permits from the Corps. So we are implementing more stringent processes for activities that happen in the ONRW, but existing uses, historic uses, all come into play with that water quality and watershed. So we're working on it. We want to establish higher protections for waters that meet the criteria of an ONRW, and I think every ONRW that this commission has designated has met the one or more of those criteria. So they are special waters. They just may not meet the standards yet.
I hope you understand the quandary that it seems to throw out there, or just from surface value. Um, the two things almost seem to contradict themselves. So it just gives me pause when I see that. You know. So thank you.
Hey, Commissioner Dominguez, I would also point out too that being listed as impaired, it provides mechanisms for us to continue to restore those water bodies and work towards attaining better water quality. So it's not necessarily a bad thing if they are in need of some help, that we then are able to put some protections in place.
Okay, other questions or comments? We need to approve this. Must be submitted to EPA by the 1st of April. So if there are no other questions or comments, I would entertain a motion to approve the 303, the 305.
Chair, I move approval of the State of New Mexico 2024-2026 Clean Water Act 303B, 305B, the great list of access equipment.
Second. Questions, comments, discussion? You ready to vote? Again, we'll do it by voice vote. Another organization I never resolutions and things like that happens down the road. Okay, all in favor of approving the motion to approve the 305D list, say aye.
Aye.
Opposed? Okay. Thank you very much.
Thank you, Chair Thompson and Commissioners. We did submit a draft order for your signature to Ms. Bowen and Ms. Jones. So if you want to send that back electronically or yeah. Okay. Thank you so much.
Thank you. Agenda item 6 is WQCC 22-01, parentheses A, Cannon Air Force Base, a petition for a permanent review of the discharge permit renewal and modification for BP 872. Mr. Knight, good morning.
Good morning. Chair Thompson and commissioners, I think Chris is also here.
Get someone in there.
If everyone's right now, Mr. Knight.
How's this? Chair Thompson, members of the commission, Andrew Knight, so Environment Department, and I would ask that we consider these next two items together, if all right. Item 6 and 7 both have to do with Cannon Air Force Base. I'll note the agenda mentioned my colleague Lisa Shai as the attorney, but I am the attorney. And again, I believe Major Anthony Fritz is counsel for the Air Force and he's on the platform.
I don't see him.
Well, if not,
There's a person I don't recognize, Maureen Dolan. Is that with the Air Force?
perhaps, I'm not sure.
Okay.
Can you scroll? Is it possible to see if there are more people, or is this it? Is this the only? Are these the only people online?
No. That view we probably need to change. Major Threats has been trying to get on the platform. I'm not sure whether or not he's one of the call-ins, or if there's anyone else on the platform that's representing the Air Force. Speak now. we've resent Major Press the link several times.
Mr. Knight, is Major Threats participation essential for this?
I don't believe so. Where I did communicate with Major Threats as recently as yesterday, and I will attest that he confirmed to me that the Air Force is in favor of continuation of the stay as is in complete agreement on that one with your told.
Okay.
Chair Thompson, if I may, and Mr. Knight, the stay orders in the past have been only for 90 days. Seems rather inefficient considering how long it's lasted. Would the parties be amenable to an indefinite stay? And when you would like this back on the commission's agenda, just filing a notice or request?
Yeah, took the words right out of my council. Yes, we would ask we establish and say both these matters. It's just much more efficient. We will certainly let you know when it is time to when we would like to say that one party or the other or both. I'm sure we'll come up with the commission the motion to request that one or both states.
Okay, so let's step back just a minute or two. Mr. Knight has requested that we consider items 6 and 7 together. I don't have any concerns about that. Does anybody on this commission? Okay, so Mr. Knight, go ahead and just give us a real brief summary of what the issues are and why we're here.
These are very related matters. They're let's see, there's several different pieces of litigation involving Canada Workspace and New Mexico Environment Department, and those two of those are the items 6 and 7 before the commission at the request of the Air Force. The Air Force has appealed a compliance order in the first case, I believe, in the second case, a determination of permit is required for either study activities. And both of these matters are being mediated in the kind of circuit right now. And those, while I am, I guess, I've been scolded by the kind of circuit mediator for describing or characterizing the state of those negotiations. I'll just say the negotiations are continuing. We believe that they will resolve these matters before too terribly long. And, we just, it will probably remove the need for this commission to take up either one of those matters. So, if we can resolve them in the 10th Circuit mediation, I think we can withdraw those matters and save the commission's time and effort to consider them separately.
Okay, so this is the request for an indefinite stay. I assume that requires a motion and action by the commission. Questions for Mr. Knight?
Just for resolution purposes, like what is the estimated indefinite? Will there be a resolution ever for this, or?
Yes, Commissioner, let's see. While the history mediation certainly has gone on much longer than anyone anticipated so far, I think we hope that, sometime, in the next few months, we have been making progress, although much more slowly than we hoped. But nonetheless, we are a long way from where we were when this stay was first requested, and we are hopeful that, a few more months will suffice to reach a resolution. But as we've seen, as history has shown us, it often takes longer than we would like. So I think an indefinite stay will prevent us from having to keep coming back here. The same thing over and over.
Questions? Ms. Jones, has Major Threats been able to log in yet?
He's not on the platform at this point.
Okay.
Major Threats is on the phone line, still unable to access the WebEx. But reiterating what Mr. Knight said, we are also in favor of an indefinite stay, and we've made substantial progress towards resolving a settlement between the parties, which would probably resolve the need for these two cases to even go forward.
Thank you. Gives me comfort that you're participating in this, because I hate to take action without your participation. So I would entertain a motion to grant the parties an indefinite stay on WQCC 22-01 parentheses A and WQCC 2331.
Mr. Chairman, I move that the commission grant an indefinite stay to the parties in items WQCC 22-01A and 23-31.
Second.
Okay. Been moved and seconded. Any questions, comments? We're ready to vote? Mr. Chair, please.
I'm fine with an indefinite stay. It would just be good if we had sort of a process for touching base with the parties, maybe every 6 months or something. Whatever.
Yeah.
Just so this doesn't completely fall off the screen, as you kind of did already. And that could be the council just contacting the attorneys and just saying, "You feel good?"
Yeah, I'm happy to do that.
Okay.
And Chair Thompson, I was just going to say, if this issue does come to resolution, it'd be nice to give an update to the commission once it does.
Yeah, certainly, Chair and Commissioner.
Chair Thompson, Mr. Knight, just going with hypotheticals, hopefully the mediation continues to make good progress. If things went south and the mediation fell through, then of course the stay potentially would be lifted at that point, and the commission would proceed with both of those cases. Is that a realistic hypothetical?
Yes, that is a realistic hypothetical. Sorry, for sure.
Okay, thank you.
Any further comments, questions? We ready to vote? Okay, all in favor of the motion to approve indefinite stay for WQCC 2201 parentheses A and 23-31. All in favor, please say aye.
Aye.
Opposed? Okay. Thank you, Major Threats, and thank you, Mr. Knight.
Thank you, Commissioner. Thank you, Commissioner.
Yes, you're welcome. Agenda item 8 is WQCC 22-55. Mr. Dominguez?
Mr. Chair, before we leave this last item, I'm assuming, know if Mr. Knight was going to create a draft order or the council will just create a draft order.
Mr. Knight, did you hear that comment? Will you prepare a draft order for us to sign regarding that indefinite stay?
Yes, Mr. Commissioner and members, I would be happy to do that.
Thank you. Let me ask the commission's pleasure. It's 10 o'clock. Would you like a 10, 15-minute break? We want to just power through. Okay. I'm seeing some heads nodding. It looks like we're going to keep going. So again, this is agenda item number 8, WTCC 22-55. It's a discussion of jurisdiction on some discharge. Well, it's something from an OCD intent to require discharge permit. So we've got, I guess, a presentation from Mr. Rose, his partners.
Mr. Chair, this is Louis Rose with Montgomery Andrews representing 3 petitioners, 2 our entities and the DCT entity. With me at the table is Jessica Renee, who's counsel for the OCD, and Christina Mulcahy, who's counsel for 2 other matters that were appealed under the same statutory provision that are currently pending on remand from this commission back to the OCD. So, because this matter affects all 5 of those, the 2 petitions that are currently in front of OCD, and the 3 which you've heard an argument about before, they're here, and I think that Ms. Mulcahy had both adopted the position that we took in our memorandum of brief that we filed to the commission, as well as requested time to do some additional briefings. So I don't know procedurally whether that's something you want to entertain before argument or how you want to do that. And then secondly, I wanted to point out that the matter you just heard with Cannon Air Force Base, one of those is an appeal of permit required determination as well. So it isn't just the OCD's permit required determinations that are currently before you. So however you decide this to affect that as well. And I don't know whether the Air Force or ED wanted to weigh into this discussion, but that's something you may want to consider as well. So I can certainly make a presentation if you like, or perhaps you can decide procedurally how you want to deal with it. You've got memorandum from your counsel. It's pretty clear that we don't agree on what the statute says, what allows you to do. And we can start from there. It's really up to you, Mr. Chair, sort of how you want to proceed with this and what would be the most to get the requisite information in front of you to make a decision.
What's the pleasure of the commission?
Mr. Chair, I mean, our counsel has prepared memorandum on this issue, and I think it would be useful for her to discuss it.
Yes.
I'm happy to do that, but I just want to briefly address Mr. Rose's point regarding additional parties weighing in on this. It would be my position that Mr. Rose has more than adequately conveyed and briefed the opposing perspective of what the statute reads and how it should be interpreted. I'm not sure that additional information would be necessarily beneficial to y'all's consideration. But if you do want to hear from other parties, we should probably do that now and then reschedule this discussion for a later date. But I would do that up to the commission whether you want more information. I hope everyone got the memorandums. They were filed. In my view, there's pretty much just 2 perspectives.
So I'm inclined to hear from Mr. Rose first and then respond. If that's okay with the commission? Okay, so if you just like to proceed, Mr. Rose.
Certainly, Mr. Chair, I think your council's outlined the issue here, the question. When we filed our petitions, we based it both on the statutory provision, what is it, 74650, as well as your reg 20.6.2.3112B. And the discussion and the briefing that you had relate to both the regulatory provision and the statutory provision, but primarily focused on the statute. And the issue is relatively straightforward under the statute. It lays out the number of actions that you can take based on permit applications. First, in terms of permitting discharges, it grants the commission, requires the commission to, by regulation, require permits for certain kinds of discharges. You've done that, have done that. The commission's groundwater discharge permit regs date from 1976 and 77. Provision we're dealing with here, 3112 in the regulations, was adopted by the commission after the Court of Appeals in the Bowden case reversed the commission's adoption of toxic pollutant regs and sent it back to the commission. And the commission adopted a set of requirements applicable to toxic pollutants that gave certain discretion to the constituent agencies, but also provided for review, which is what 3112B does, provides for review by this commission of those decisions, whether a pollutant is a toxic pollutant, what the criteria are that apply to that, or whether a certain discharge is exempt. And so those regs came out of that. They've been operated under, and this provision hasn't been, and the language of the statute at the time, and you see this substantial briefing on permit English, that's the Court of Appeals decision reviewing the revised groundwater discharge permit reg and the provisions applicable to toxic pollutants. And the Court of Appeals affirmed this commission's action in adopting those regs. The debate that we're having with your council is over the scope of that and whether that decision necessarily approved the 3112 provisions as authorized by the section of the Water Quality Act 7465 that we referred to, or whether that was adopted, or whether that was approved strictly on the challenge to whether it was an improper delegation under the statute. And quite frankly, the decision speaks for itself, but what we don't know, and I've asked this fellow, and I don't know whether she is privy to what was actually argued in front of the Court of Appeals. I tried to remember, I went back that far, I just don't remember exactly what was argued or how it was argued. But, and I also don't know, and queried Ms. Bowen about whether you had or she had copies of the Commission's decision or statement of reasons adopting the rules, what the basis for the Commission's adoption of what's now 3112B is. I still don't know what that is, and so we're sort of opining on something, and we don't know what the Commission's decision was or what their position was as to the scope of the statute. As we point out in our briefing, the statutory language allowing for this Commission's review of permitting actions has changed some, but hasn't changed substantially since that decision was made. As we point out, that the section dealing with approval of permits or denial of permits also included language about review by this commission of those decisions. That the legislature's amended that section since, divided that paragraph into two paragraphs, and the paragraph referring to this commission's review deals now with permitting actions. The debate we're having is over what the scope of that means. Ms. Bowen and the agent's office seems to read that term as being limited only to those specific permitting actions that are spelled out in 7465. We believe that, in fact, it's broader than that and encompasses the determination of permit required or whether a permit and an applicant would be exempt from permitting. We've cited a couple of Court of Appeals with one dealing with the Radiation Protection Act and the second dealing with the Hazardous Waste Act that we believe support our position that the term permitting action in that statute can and should be construed more broadly than the AG's office has recommended to you. We believe that in terms of reviewing these decisions, that's the proper administrative action. It's really your regulations which are being construed here. We think you should be the ultimate, we think the statute provides that you're the ultimate arbiter of whether or not those provisions apply. That said, if in fact you agree with the AG's office, and parenthetically, we sort of had this debate when the petitions were initially filed, as you recall, then counsel for the commission raised in essence this issue. Before you determined to remand the 3 items I'm involved with back to the OCD for determination. And so obviously you remanded it back to the OCD based on what you thought was your authority over this matter to begin with. Otherwise you wouldn't have had the authority to remand. So we remanded it, we've gone through that process, we've briefed it, we've argued the substance, we've had a vote on the substance, and now we're back to determining whether or not you had the authority to consider this in the first instance. I'd like to point out that while the AG's office said that the real remedy here is for my clients and others to wait until they have the permitting decision as the AG's office has outlined it, I'd just like to offer that I can't imagine the company challenging the need for a permit. We go all the way through the permit process, obtain a permit, and then try to challenge whether or not a permit was required. That process makes no sense. I think the real outcome here is to give the companies a couple of options. One is, and we talked about it the last time, the companies could say no to the OCD and force the OCD to bring an enforcement action, and then challenge the decision as part of an enforcement action. As we noted, that would give rise to potential substantial civil as well as potential criminal sanctions. And while the final decision would be that of the commission, we would still have an allegation from the department that companies violated the statute and were subject to sanction. And I think that's just the wrong message, and I think it's inappropriate in this context, and quite frankly, creates a certain substantial jeopardy for the companies before getting a determination. The other option, which we didn't address at the last meeting and we haven't addressed here, is my belief is that OCD's determination is significantly final to be challenged. And if there's no appeal to this commission based on that, then the remedy provided would be either a writ of cert to the state district court or a declaratory judgment action in the state district court that would be construing or determining the propriety of the OCD's action, but to which, as far as I can tell, the commission would not be a part of it. And that makes, from my perspective, doesn't accord with the statutory grant to this commission and its oversight responsibility over administration of the act. Quite frankly, I'd rather have you decide these things rather than going to the various state district courts around the state to make that determination, perhaps ultimately to the Court of Appeals. I might also add that there's a separate appeal provision in the Water Quality Act to the Court of Appeals. It uses the same language as 7465 that we're debating. It allows for appeals of permitting actions. I assume that if we were to take this matter, if you were to agree with the AG's office and rule that you had no authority to consider these reviews, that an appeal under that provision would be met with the same argument from the AG's office. The statute wasn't broad enough to encompass an appeal directly to the Court of Appeals. So my sense is that depending on how the companies would want to proceed, we might want to file an appeal directly with the Court of Appeals and also file a complaint with the state district court, either asking for cert or asking for declaratory judgment on the grounds that it's not clear that the Court of Appeals has jurisdiction. Again, it's my understanding of the statute and the rules, and the reason why we filed the petition we did is because it was our understanding that, one, that this was an appropriate decision for the commission to make, and secondly, that the statute and the rules could be construed sufficiently broadly to encompass your review of them. We still believe that. We've cited what we believe are applicable cases, and while we debate what Kerr-McGee decided and what it didn't decide, I'll note that if the AG's right, the parties that challenged that determination didn't challenge it as being a violation of the statute, and knowing the parties that brought that action, if they thought it was a violation of the statute, that certainly would have been raised. They weren't hesitant to raise and challenge any action by this commission. So granted, that's not evidence, but that's another reason why, in my mind, the Kerr-McGee case decided that you had authority to review these decisions. I'll point out that, like I said, we don't know why the commission adopted those provisions and what it thought its authority was at the time it adopted those decisions. The commission could have decided when adopting 3112B that the appeal provision for actions was sufficient. It could have decided that its authority generally to adopt regs to require permits for discharges was sufficiently broadly included, or they could have decided that the general grant of authority under 76.4 to the commission to adopt regulations to prevent or mitigate water pollution was sufficiently broad to encompass that. Nothing in the rule itself spells out what the commission thought the basis for that rule was and why it adopted it. And we certainly don't have access to the commission's deliberations or, quite frankly, their statement of reasons as to why that was adopted. So any sort of argument on this, I guess, is speculative because we just don't have access to that. Perhaps the AG's office does, but we certainly don't. And so I'm not sure, and I think it's hard to argue what the commission should do and what its basis is without knowing why it did what it did and what it thought its statutory authority was at the time. The other option I think you have, we think our position is supported by the statute and the case law. We think it's more in accord with how the legislature set up this commission and its responsibilities. I suppose, if you wanted to change your position and say that 3112 is broader than the statute, you're determining that the reg you've adopted is invalid. The way to do that, I think, is more probably to go back to rulemaking and appeal. That said, we're in sort of a quandary as to how to proceed. And quite frankly, like I said, I wish we'd had this debate, what now, a year, 18 months ago when this first came up. And in part we did, but maybe, now we can get some resolution of this going forward. But my sense is, and like I said, we're still of the mind that it's a proper role for this commission to take, and that the legislature's granted you the ability to do it, and to proceed from there. And I'm available for any questions if the commission wants. And would suggest that perhaps you might want to query the division as to their take on the statute as well. Thank you, Mr. Chair.
Thank you, Mr. Rose. Mr. Dominguez.
Thank you, Mr. Chair. I was looking back at our meeting minutes from the January meeting when we briefly talked about this, and part of that outcome was it would be scheduled for today, and that both OCD and the petitioner will submit a briefing. I've seen the briefing from Mr. Rose, but I'm not finding a briefing from OCD. So is it not on the document page, or am I just missing it?
Commissioner Dominguez, Mr. Chair, thank you for the question. As you may realize, I was not in attendance at the January meeting. There was some miscommunication regarding when that hearing would or would not be scheduled. And I was at a doctor's appointment, so I didn't weigh in at that meeting. I have since followed up, reviewed the record, and it was my understanding that briefing was invited from the parties and not required. This was a position, the division looked at this argument early on in this case and made the determination that it would not pursue an argument that these particular discharge permit required determinations failed to meet the permit or permit action. So it was the division's position all along that, at least to the regarding to these discharge permit required determinations, that these were appropriate for review by this commission, and that the division wanted this commission to weigh in on the question of the potential versus actual discharge authority under the regulations.
Thank you.
Commissioner Thompson?
Yes.
If we may, good morning. I'm Kristen Pahey, and I represent Ponto Midstream and San Mateo Dale K Black River Midstream. We are also two parties here that Ms. Bowen referenced. We have matters currently docketed and pending before the commission. Those matters are WQCC number 23-13, WQCC number 23-12. We are similarly situated to Mr. Rose's client, and we requested the opportunity to brief this matter on a motion for review from the commission. And while Ms. Bowen seems to oppose that, I would remind the commission that she is not a party to this case, and that the parties here before the commission, Mr. Tremaine on behalf of the OCD and Mr. Rose on behalf of the target parties, do not oppose us joining this matter to brief it before the commission. We would make that request because while Mr. Rose has done a great job of briefing the issue, we also have matters that we would like to weigh in on because the commission's decision directly affects our matters before the commission. And if we are not able to weigh in here now, we will not have an opportunity to do so. We believe that both fairness and due process both allows us and requires us to weigh in right now. We would ask the commission, as part of this matter, to consider our request to also weigh in. Thank you.
It's a pleasure of the committee.
Mr. Chairman, this is a pretty big issue, and not only do we hear from our council, but I would also hope that, I would also offer that the Environment Department might want to step in on this issue today. As Mr. Rose has pointed out, they have a case before us involving the same issue, and I think this issue appears numerous times from the Environment Department. So any decision we make will have implications for their discharge permit program also. So I would gladly have them have the opportunity to say something to this issue.
Thank you. My recollection is that the Environment Department has been silent on this till today. Is that true, Mr. Norris?
Mr. Chairman, commission members, as far as I know, yes, that is true. We've checked the position so far, and I am not aware of any discussions or any movement towards taking a position.
Okay, Mr. Chair, let me point out that the comment from the advice from the AG's office was limited strictly to the TARP and the DCP appeals. You haven't heard from the Environment Department or from the Air Force because it wasn't raised in the context of that case. So, I agree with Commissioner Brankert that this has broader application and might be prudent for the commission to hear from those parties as well. Also point out that one other option that we looked at in terms of the challenge was to treat the OCD's permit required determination as a compliance order and seek review under that. We chose not to do that because we didn't think that's what the OCD style their decision has, but certainly you could, I suppose, construe the letter requiring a permit as an order to submit a permit application, which would be reviewable under the enforcement provisions of the statute. So that's another way to get it in front of you, but we'd be right back here again if you were to construe that letter that way. You know, certainly, you know, we thought it was a determination that a permit was required that was reviewable under the permitting section, but if this commission were so inclined, that's another avenue I suppose you could take. If you may want to talk to your council about whether that's an option in this.
Mr. Chair, members of the commission, if I may. It is correct, I'm not a permitting officer. I am your legal counsel. In this case, what you're looking at is strictly whether or not your statute provides the authority for you to review the Secretary's determination absent some sort of accompanying permitting action. It's a strict legal question. And I did raise it in the context of these cases because they're currently pending, and it was admittedly the first time it came to my attention. Unfortunately, it didn't come to prior council's attention, or maybe it did, and they decided not to open up this can of worms a year and a half ago. And so, unfortunately, Mr. Rose and his clients are facing this in the middle of this case rather than the beginning of the case, which is when I would have rather have brought it up. To that end, I could have also brought this up simply not in conjunction with any case, because I'm your legal counsel, and I can always bring issues to your attention when I think that we might be violating the law here. I wanted Mr. Rose to provide an opposing position because this is how things have been done in the past. And I understand the interpretation that it has been given in the past. However, this is looking at your statute, looking at the plain language of your statute. It is very clear to me that a permitting action is limited to those outlined by the legislatures in your statute. There have been some issues brought up about how this will play out moving forward. And there's some concerns that this will cause all sorts of troubles. I have a very simple solution. And it's that you read your rule 3112 to harmonize with your statute. The solution provides a number of benefits, not just legal compliance, but it also will allow for an administrative record to be created prior to these permitting determination appeals coming before you. You'll notice that every time that a secretary determination comes before you, you almost always have to remand it back to the constituent agency to create some sort of administrative record. This is remarkably inefficient. There is no appellate court, no reviewing court that would look at a case that didn't already have a record established. So what's happening is they're filing their petitions, they're saying, please review this. You're saying we don't have enough information because you don't. And it gets remanded back. They create the administrative record, and then it comes back. Based on an accurate interpretation of your statute and your rule, if you say these determinations must accompany a permitting action, they will come before you with the administrative record already created. You won't have to take the time to remand it. You won't have to take the time to put it on your agenda and decide, oh wait, we don't have enough information for this. This has the second added benefit of allowing for public notice. Throughout your statute and throughout your rules, and just generally public bodies, require public notice when we're conducting business that might affect the public. Well, right now, a secretary determination doesn't necessarily require any sort of public notice because the party hasn't made an application for a permit. There's been no permitting action that occurred. And your statute and rules all outline the procedures for public notice when an application has been submitted or when some sort of permitting action has occurred. So if the determination, secretary's determination, accompanies a permitting action, the public will get notice of that. And that's good public policy just generally to keep them informed. I also want to note, if you look at your statute 465, you look at the plain language of it, subsection N and O, it lists what constitutes a permitting action. We're debating what constitutes a permitting action. Mr. Rose would ask you to add language into the statute that's not already there. This is contrary to statutory interpretation. It's contrary to just plain basic reading interpretation. It lists in N what constitutes a permitting action, and then it references that permitting action in O. The rule, the regulation that we're saying here might be overly broad, also references your statute and says that it garners its authority from that statute, and that the procedures within that statute are how you are governing. In addition to referencing your statute, it says that proceedings before the commission shall be conducted in accordance with your adjudicatory procedures, 20.1.3, and it cites that. 20.1.3.7 has definitions. It defines permitting action. It says those actions that may be appealed to the commission pursuant to the Water Quality Act. Your statute is the Water Quality Act. Your statute defines what it is. Those are the actions that can be appealed to. This makes sense just on a plain reading. It makes sense in accordance with basic statutory interpretation canons. And it makes sense procedurally. And most importantly, in my mind, it makes sense from a public policy perspective. So the solution is easy. It's not that your regulation is invalid. It's not that you guys created something that is contrary to your law. It's just that your regulation must be read to harmonize with your statute. They will still get the review that they see, as long as it accompanies a permitting action. Now, this might be a little bit messy for the constituent agencies and for the parties at their level. They'll figure it out. I have no doubt that they will. They will work together to determine what is the best way to move forward to ensure that a permitting action accompanies a determination and a review of that determination. They created their procedures long ago, I presume, to do it, to allow for review of a permitting action generally, and I have no doubt that they can do so again. That, unfortunately, will be a little bit of work on their end. But what's most important for this commission and what is my role here is to make sure that your laws are being followed and that the public gets notice, that you're getting an administrative record to review, not wasting your time, and that your legal interests are taken care of. I want it noted that Mr. Rose is incredibly smart and very knowledgeable, but he has a client. And his client is not you. So what it boils down to today is simply deciding that moving forward, your rule will be read harmonized with your statute. This case will be dismissed for lack of jurisdiction. It will not go away forever. I have no doubt we'll see it again. And there will always be a mechanism for review of determinations as long as they are making determinations.
Comments, questions? Let me ask, step back a few minutes. We want to give Ms. Kennedy an opportunity to speak. I'm seeing heads now, so just be brief because we've heard quite a bit already.
Sure. Thank you. I think there are a few points that I will address briefly. First of all, if you were to read the statute that Ms. Bowen suggests, she would read out of that statute provision R, which expressly provides for remand of issues that do not have evidentiary record developed back to the constituent agency. Just like you can't read language into a statute that is not there, you also cannot read language out of a statute that is there. That provision exists here for exactly this circumstance. There would be no reason for that provision to exist in the statute, but for this instance, which is an appeal of an agency determination that a discharge permit is required. The fact that there is no evidentiary record in this matter and that it was remanded to the agency should not dictate. This commission should not give way to efficiency for what is written into its own statute and its own regulations. 3112B expressly provides for review of a permit required determination. If the commission determines that that regulation is broader than the statutory authority, then what this commission must do by law is go through a rulemaking and repeal that portion of the regulation. What this commission cannot do is do that here in the middle of an adjudicatory proceeding. Additionally, and because we have not had the opportunity to brief this issue, the commission should know that Ms. Bowen's position that a permit determination is not final for agency appeal, that goes against federal statutory interpretation that was just decided before the United States Supreme Court. In the Sackett matter, although it was different language, the United States Supreme Court did determine that an agency determination from the Army Corps of Engineers requiring a 404 permit is a final determination. There was no full permitting action in that case. It was merely a determination from the Army Corps of Engineers. Lastly, the best meaning of what language in the statute means, one of the main statutory interpretations, is how the agency has historically applied its own regulation. For 30 plus years, this commission has interpreted its own regulation as allowing it to review permit required determinations. Now, after 18 months, for the first time, this has come. But it's not just 18 months. It's actually 30 plus years of precedent that this would overturn. That's why, amongst other issues, we would request the opportunity to brief this in full, because while Mr. Rose has done more than an adequate job, we also have our own interests here. And if we are not able to weigh in now, we will not have the opportunity to do so, despite that this commission's determination either way will directly affect both the San Mateo parties. Thank you.
Thank you.
Mr. Chair, I think we've heard from both parties. We really haven't heard from the Oil Conservation Commission on the Conservation Division on what they feel on this as well. So I think we should see their stance also.
Thank you. I think that's entirely appropriate. Mr. I'm sorry, Mr.
Thank you, Commissioner and Mr. Chair. Yes, I was very circumspect in responding to Commissioner Dominguez's question earlier regarding the briefing schedule. OSP ultimately joins in the conclusion of the petitioners related to the facts and issues specific to these cases, and would extend that the same conclusion to the DOK and Pronto matters as well, but members do not have in front of me. But ultimately, after discussing with the parties and reviewing the material shared between the parties, it did not appear necessary to weigh in on the canons of interpretation and the structural arguments in the form of the briefing. These discharge permit required determinations are expressly subject to this commission's review under 20.6.2.3112B, And the question here revolves, I think, entirely around this interpretation of the term permitting actions. And I think you have to look back at what actually happened in this case, and there is actually a way of squaring these interpretations without making a sweeping judgment as to the full definition, potential definition of permitting actions. What OCD did in this case, and the reason that these district court required determinations are before the commission, is that over a decade ago, it made a decision to terminate permits. The decision in 2020 was to reverse that termination of previous permits. And then that decision extended to a certain number of facilities operated by the same operators, a limited number of which did not previously have discharge permits. So the language in N, in 74-6-5N, that's in consideration here, says that if the constituent agency denies, terminates, or modifies a permit, or grants a permit subject to a condition, et cetera, et cetera. And then I think there is a general agreement that O refers back to the language in N. And the question is whether or not this discharge permit required determination fits within these different categories of agency actions in N. So denies, terminates, modifies a permit. We do agree, potentially, I would say hypothetically, because these cases are not currently before the commission, with some of the construction arguments. Not all constituent agency actions in orbit around a discharge permit will be permitting actions. Okay, and if an agency, constituent agency, takes an action that is not a final agency determination, that does not constitute a permitting action, then that action would not be right for review by this commission. However, where we land in this case, because the factual history here and the specific actions taken by the division, we do agree that these particular discharge permit required determinations are appropriately subject to review under 3112B and 74-6-5 and O. So essentially, the division's position is that at least some discharge permit required determinations are permitting actions, and that the ones in this set of 5 cases are permitting actions. And we ask that the commission make such finding, make such a determination, and then proceed to reschedule the vote on based on the record and oral argument from October.
Thank you, Chair. Mr. Tremaine, this would have been very helpful to have had this position from the impact division earlier. So I just want to clarify that it's OCD's position that this was a modification of a permit.
I think that this could be, thank you, Ms. Bowen. I think that this could be, we've discussed at length in this case how the procedural history here is moved. I think that there's an argument that it relates to either a termination or a modification of a permit. This really depends on which specific facility we're talking about. Some of the facilities did not previously have a discharge permit, but in general, we're talking about facilities that did have discharge permits. There was a termination, and then the 2020 division decision was to reverse that termination. So I think that that decision could be reconciled as a termination. I mean, I don't read this language so narrowly as to say that a termination is appealable, but the reversal of the termination is not appealable. I think what complicates the matter here is that decade in between those two decisions that has us all wound up for the entirety of this case. I think on these limited facts, I would also argue that it could be considered a modification of a permit as well. I lean towards termination.
Sorry, I misunderstood. You lean towards termination?
I think that. Sorry.
I just was clarify that last statement.
Yes, Mr. Chair. I think the strongest argument here is that OCD terminated permits and then reverses decision to terminate, and so these are reviewable as agencies' final decision, a final decision related to the termination of a permit.
Mr. Chairman. Thank you. So I just want to know, I mean, if this is accurate, that this is a termination or termination action, then that would conform with the statutory interpretation that I've been making. This is not the argument that Mr. Rose raised, and that was the argument that I was addressing. That being said, it sounds like in this limited case, and I guess I don't know enough about the OCD procedures regarding termination of permits to know if this is very similar to when permits are actually terminated. And if you follow all of the same public notice requirements and due process procedures when you issue this secretary determination as you would have otherwise when you either terminated or modified a permit.
Ms. Bowman and Mr. Chair, I think that's a very difficult question to answer because OCD did not have a groundwater discharge permit really in practice during the period of time after the termination. As we discussed at the oral argument, the agency determination in 2012 was essentially that based on inquiries to operators who at the time had discharge permits, and really to the question whether or not they intentionally discharged, that the division issued conclusive determinations to terminate permits. And those letters were sent to operators. They were not noticed publicly, and they were not justified. They were not substantiated or explained in any way. They were conclusory letters that stated, we asked you, the division asked operators for a response to a single question, and after reviewing those responses, the discharge permit is no longer required. So there was no notice and process. I mean, I think that Mr. Rose may wish to join here, but I want to go back to the statute because my reading was that the notice requirement attaches to the discharge permit application and not the agency determination. But that's a different separate question. I think I'd have to go back and look at that in more detail.
And Mr. Chair, if I might, I think Mr. Tremaine was right that the number of facilities that are subject to these three appeals didn't exist at the time of these fighting out 2010, so there was no permit in place. The subset of facilities that were, my recollection of the record in this case, and perhaps Mr. Tremaine may remember more than I do, but I think it was you put all of those prior letters withdrawing permits or telling facilities they no longer had to continue permits, I think is in the record of these proceedings. So I think procedurally how that occurred is in front of you. Our point is that these are permitting actions within the context of the statute, we didn't try to qualify them as specific actions under N because, quite frankly, we don't think they are. And so, and one thing I wanted to allude to, Ms. Mulcahy brought to your attention the language about where the legislature has obviously dealt with issues where there is no record in front of the constituent agency being reviewed and provided a process to remand for further proceedings. Remember at the time that 3112B was initially adopted, the permitting section actually provided for a de novo hearing in front of this commission. It was only after that what's I think now kind of called a hybrid proceeding is in front of you, where you have a record developed in front of the constituent agency, but your review is not an appellate review, it's really a review of that record and making independent findings based on that record. And my recollection is it was based on the model from the Coal Surface Mining Commission and their statute. So, but the statute changed in terms of the kinds of review you have in front of you after these rights were adopted. So, but I think the legislature accommodated for that, and as Ms. Mulcahy pointed out, that's the reason why the provision's there. I think Ms. Bowen's right. The preference would have had a record in front of the agency and played it out. That wasn't the process the agency chose to use. It's really their discretion to decide how to do that. But that would be my preference too. Is it, and I'll point out that maybe this is too much into the substance, but the regs contemplate a notice of intent and then a determination of exemption. And so the agency would have in front of them a notice of intent, a description of the discharge and the underwater bodies into which the discharge was occurred. So the kind of record is no one's talking about, we think are consistent with our construction of the statute. That is that when the agency makes that determination on a discharge, they would have information in front of them to make that decision. It wouldn't need to be remanded. This procedurally is in a different posture, and therefore we've had to deal with it that way. But like I said, I think that the statute contemplates this and provides for the kind of record Ms. Bowen was alluding to through the process of remand and proceedings in front of the OCD, in this case, the constituent agency, which we did in this case. We developed a record, we provided, as you see in the record, the company identified the equipment, the facility, what its intended discharges were, where what measures it had in place to deal with unintentional discharges. And that was the basis on which the OCD made its subsequent determination that was on appeal to you, and that we fully agreed. So I think, like I said, I think our construction is the better construction, and that I still would say that you may want to wait, ask ED if they want to wait in, and the Air Force for that matter, since they have an appeal in front of you. But I think you now have this sort of the breadth of the argument and decide how you want to proceed with this.
Mr. Chair, if I may, Commission, Mr. Rose brings up a good point, which is that generally speaking, in almost all these other cases, the petitioner has asked for the remand, has requested it, because they want evidence to be presented. They want the constituent agency to present their evidence, and for that record to be fully developed. And there is this subsection R, which is a catch-all for remand. But why would this commission get these cases, put them on their agenda, review them, determine that you don't have enough information, and then remand it? It's a remarkably inefficient process, and it's not really how any other review work works. By simply agreeing that 31112, your regulation allowing for the review of the second determination, should harmonize with your statute and be accompanied by a permitting action, you'll avoid this unnecessary backlog of cases that have been remanded for years. And I think actually in the long run, this will benefit almost every company that comes before this this commission asking for constituent agency review. Now, I understand that Mr. Tremaine is presenting today that this should constitute as the termination of a permit or a modification of a permit. And that might be the case if the parties want to agree that that is true. But then the procedures for terminating or modifying a permit needed to be followed. And I'm not sure if that occurred here. And I apologize, I haven't reviewed it under this argument because this was not an argument that was raised until today. I was addressing solely Mr. Rose's argument, which was a different statutory interpretation argument. I think that what you folks want to do with this case may not be controlling for how you want to address other cases. It sounds like there's an argument that this is different in terms of substance. However, I think there should be a determination by this commission that 31112 must harmonize with your statute and must be accompanied by it.
Okay, thank you. How do we want to proceed? Mr. Blanker.
Thank you, Mr. Chairman. I hesitate because it's dangerous when Council Rose and I start going back through history, cleaning things up. Mr. Rose is correct. 31, the rule that allows for the direct appeal of a termination is efficient. I think that the McGee case is some 40 years old or more. And I will, in full disclosure, admit that when I was counsel to this commission back in the last millennium, there was a case before the commission on this issue in which somebody challenged a secretary's determination. Actually, it was almost identical to this scenario where the Environment Department said, no, you didn't need a permit, and then years later said, yes, you do need a permit. So it was a commission. But I will strongly disagree with Mr. Rose on his characterization that the Water Quality Act has not changed much since then. Back in those days, as you look at the Kerr-McGee case, and as Mr. Rose has noted, all appeals to this commission were what's called de novo. In other words, you start it all over. You present all the evidence to this commission. Okay? And so, looking at a permitting decision about whether to require a permit or not made perfect sense. You came in with the evidence about that and presented to the commission. Okay? In 2005, the legislature really made significant changes to this commission's authority. It's stated in the new sections, and the council has mentioned subsection R, subsection Q also, that basically a whole record must be developed for the constituent agency on a permitting action, or you can bring it to this commission. Okay? And including the opportunity for a public hearing before constituent agency. Okay? And so that's totally different. We're no longer an evidentiary hearing body. We're now just reviewing a record developed by the agency. In response to that, this commission adopted a series of rules. I think it's 3108. It's the process rule. It goes on in detail about how what applies for a permit, all the public notice you have to provide, all the opportunity for comment, for a public hearing. And so that integrates the whole process of creating the record into our rule. This scenario doesn't fit that. Okay? We're stuck with this old rule that really is part of the past. It happens. As Jerry will know, the Oil Conservation Commission had a rule that the Supreme Court threw out many years ago in the Maudlin case, and the commission didn't repeal the rule for maybe a decade. It just sat there in its rules. It happens. So the problem is how to integrate this, and I think council here and Bowen have tried to figure out how do we integrate this type of review into our existing statute and process. One option that Mr. Rose pointed out, which, maybe the simplest one for today would be that the constituent agency treat, the failure of a company to say, sure, here's our permit application, as a compliance order. Yes, you will give us a permit application. And then we have a whole rule about how you appeal a compliance order. Okay? So that's a simple way to do this. The remand, I think, is a possibility. We've already done the remand, but the problem with the remand is I don't think it works unless we fit it into at least part of the process, public process under 3108. That there be public notice and an opportunity for a hearing. I don't think we can start at the beginning, with the application for a permit. It's more the second step when they say there's the version is sort of a draft permit and you're responding to it. In this case, I think it's the application, maybe the application for a permit exemption. It doesn't apply to us. Okay? And you treat that as, something that will go down as the department, the agency rejecting that application, and that decision, the rejection then gets public notice. There's an opportunity to comment on that and present evidence to the parties. Okay? And the problem is we're just kind of making this up. Which I guess you could do under a stipulation parties, to make this up. And really, I think Mr. Rose has said, what really needs to be the answer here is that we need to go back and work our rules a bit. Sort of craft this, insert this process into the 3108 process for how you make a decision, how you get notice and comment on that proposed decision. So I don't know whether council will agree to some sort of stipulated process on the part. Take this back to the agency, allow for public notice, opportunity for a hearing, allow for the fuller development of a record, and the compliance order may be the easiest way to get it back to us that fits our current regulations. But I think that's sort of the options we have. Of course, Mr. Rose is ready to file lots of lawsuits. So
If I may weigh in on that, Mr. Johnson?
Yes.
But I think there's a few issues here. The first of which is 3108 expressly only applies to applications for a discharge permit modification program. And so I think while Commissioner Brancard's suggestion is a nice halfway point, it's not provided for in the regulations. And this commission is bound by its regulations. There is no wiggle room. And so I think to say that this is an application when we're saying we do not require a permit is a far greater stretch of your regulations than the fact that a permitting action can cover a determination that a discharge permit is needed. The second point is, while I cannot say for sure, I find it highly unlikely that my client or anyone in their situation would go through an entire permitting process to say we don't need a permit, and then to land back here on that appeal. More likely than not, what we would do is we would go to the district court and get a declaratory judgment, in which case what that would in practice do to this commission is it would take what is supposed to be this commission's expertise, which is whether and under what circumstances a discharge permit might be needed, and that would give it to the district. The district court, in all of the different judicial district courts in this state, would be making that decision. And so what in turn would happen is you would have wildly different determinations about when and under what circumstances a discharge permit might be needed. Instead, what this commission could do is to say permit is ambiguous language. While Ms. Bowen's interpretation is certainly a reasonable interpretation of the statute, it is not the only reasonable interpretation of the statute. And in fact, in other statutes, where the legislature has meant to limit something to a permit decision, meaning
strictly a decision about a permit or application for a permit in front of them, the legislature has used the word permit decision, including in other sections of the Water Quality Act. But the legislature didn't do that during the statute. It used different, broader language. Permitting action, that's what it used. So we would suggest to the commission, rather than twist the regulations even further and read into them language that does not appear there in 3108 and that is quite clear on its face, we would suggest that this commission do what it has done for the past 30 years, which is to review permit determinations such as the one before it. And not every case is going to need that remand. There are questions that are legal questions alone that you don't need an evidentiary record for. Thank you.
Mr. Chair, just one point in response to Mr. Brandon. Actually, I think these regs are 40 plus years old, so we did, and maybe you can take a look at them. But one thing I would like to point out is that in response to Ms. Owen, I don't think you can reconcile 3112B with her interpretation. It basically provides that what in legal parlance would be interlocutory decisions or preliminary determinations before a final determination are reviewable. It says the discharger is not exempt from obtaining a discharge permit. You wouldn't submit a permit if you thought you were exempt. The decision that you're not exempt would occur after you processed an application. The second option is that the material to be discharged contains any toxic pollutant, which is not included in numerical standards. Again, that's a prefatory or predicate decision that would be made by the constituent agency before a final determination as to what requirements might apply to that particular discharge. So both of the circumstances under 3112B would not be final actions, and I don't believe come within the construct of the Water Quality Act section and Ms. Bowden referred to. So I don't think there's a way, at least I can't figure out a way to reconcile those two if you believe that the language in O is limited strictly to the permitting actions in that.
Mr. Chairman,
Yes.
just briefly address that. Your regulation 3112 cites 274-6-5, subsection O. It cites to it, so it can most definitely move forward with it. It's also, if I may, Mr. Rose, just one quick. Your regulations have to harmonize with your statute. Your statute provides you your overarching authority. Your regulations garner its authority from your statute. And it's a basic statutory interpretation that if there seems to be any sort of confusion between the two, that you read the regulation to harmonize with the statute. Not the other way around. Not the other way around. We're not going to say that your statute includes other things than what the legislator specifically listed. I also want to note that this commission did define permitting action. You defined it in your regulations. You defined it in 20.1.3.7. Permitting action means those actions that may be appealed to the commission pursuant to the Water Quality Act 74650. That you did decide that that's what that meant. Not only is it plain on its face, it's memorialized in your rules and regulations. I understand that the constituent agency and the companies are pushing back on this because it's going to take a little bit more work on there. That's not your concern. I think that working with them to make sure that the rules and the laws are applicable across the board consistently and are correct is your concern. But how they decide to sort this out and whether or not they want to take it to the district court, I mean, that's up to them. And I think that the district court would more than likely look at this and say, yeah, you need to have an administrative record at a minimum. And they'll go through that same song and dance there too. What I'm proposing is a reading that in the long run benefits clients that Mr. Rhodes represents. I'm actually a little surprised by how much he's pushing back on it in that regard. And I understand it's probably because this is just how it's been done in the long run. In this particular case, unfortunately, we got to the very end of it, and now they're all a little frustrated that they're being told that there's an issue. But I think that if I had brought this up at the beginning, I'm not sure it would have gotten quite so much pushback. Because the statute is very clear. But the statute is very clear. And that's, I understand that there's been some complaints from the parties and from the constituent agency. This is going to be complicated. This is going to create more work. Your role here today, and what I'm asking you to do today, is to simply make sure that your reading of the law is correct. That's what I'm concerned about. I'm not concerned about another client or about the oil or gas company or about how this will look from OCD's perspective. I'm only concerned about making sure that your laws are followed.
Mr. Chair, just one final point, and I'd like to point out that if you look at 3112, I'll read it to you. It says, if the Secretary approves subject to condition or disapproves a proposed discharge plan, renewal or modification, or modifies or terminates the permit, appeal therefrom shall be in accordance with the list N, O, and P of the Water Quality Act. I think that's the precise litany of permitting actions that Ms. Bowen is arguing that you're limited to reviewing on your own. If that's the case, then there's no reason for the Commission to have adopted 3112B. Because 3112B deals with discharges that are exempt or contains a toxic element. So under Ms. Bowen's interpretation, A is the only provision that's in accord with the statute. B would violate the statute, and therefore your decision to adopt it would be ultra virus. And quite frankly, one, I disagree, but we don't know what the Commission's basis for adopting that rule was and why they thought it was justified at the time it was adopted. Because it was adopted so long ago, either in 1977 or 1981, that there is no record to explain why the Commission did what it did. And we're now contemplating whether or not it was justified without understanding what the Commission's determination was at the time. And I don't see how you reconcile Ms. Bowen's position and the language in 3112B. I think if you think 3112B is a valid exercise of your authority, it includes actions beyond those listed in that. Otherwise, if you think that permitting action in O is limited just to those actions, then 3112B would violate the statute. It would be inapplicable. And I don't see a way to reconcile. Thank you, Mr. Chair.
Thank you, Mr. Rose. Commissioner Dominguez.
Thank you, Mr. Chair. I hesitated to wade into this, but add a little bit to what Commissioner Brankard had opined on was, I think when all of these appeals were brought to the Commission, they were brought to us from my perspective as a petition for a permit review under 3112. And I think, at least I did, I looked down and like we've looked at every request for a permit review and we approved the request, and then as things evolved out, and what resulted was the remand because there was no record. And I think when the Commission did the remand, the one item was to create the administrative record, because under 3112, the commission looks at the permit and the record. Well, when we received back the administrative record, in my perspective, it did not look like we ever reviewed as an administrative record. We had a few memos from OCD basically saying, well, OCD changed their mind from the previous time, and here's some of the backstory. But it truly was not an administrative record under 3112. And that's what we, as a commission, have to work off of. Now, after hearing from OCD today, where they kind of view that this could be viewed as a termination or a modification of a record, of a permit, we still do not have a permit before the commission. We've heard part of the parties previously had permits back in 2012. Some of the other parties don't have a permit, period, because they evolved after the 2012 decision. So we're stuck in this quandary of trying to apply 3112 for a review of the permit and a review of the administrative record, because that's all the commission looks at, is the permit and the administrative record. If those items don't have enough substance or are not there, it creates a problem for this commission to actually base a decision on. But ultimately, what has come out of this whole process is, well, it's not so much a review of the permit, but the decision of whether a permit's required or not. But that doesn't fit 3112. As much as I would love for the commission to be able to easily make a decision on this, this is a cluster at best, and there's not any solution on these. But and I've been, not to try to trump my fellow commissioner on the other end down there, but I've been involved in permit reviews for 16 plus years, and they've been fairly structured and cut and dry. There's a permit, there's an administrative record. We don't have that in these situations. And possibly had all of that got fleshed out early on, we wouldn't have dragged this out as long as it has dragged out. That's water under the bridge. We're just at the point where we have to have a path forward. But 3112 provides a scope that the commission has to work on. And I'm struggling. I've looked at months trying to figure out the magic bullet but I'm not finding. With that said, we've most everything that's been in front of us is Mr. Rose's clients. There are other petition reviews before us under 2312 and 2313. Those parties being able to fully brief their situation has merit, because whatever the decision by this commission, it's going to affect multiple parties. So whether Environment Department or Air Force decides to chime in or not, they currently do not seem to want to weigh in on that. But what we're being asked to do under 3112, I don't know that we have all the pieces to the puzzle. We're just being asked to give a thumbs up or a thumbs down of is a permit required or not, and I can't fit that under 3212. That's not a permit review. I have yet to see a permit. Mr. Chair, with that said, I talked for a long time and provided no solutions. I just stirred the muddy water.
Okay, I'm gonna exercise the prerogative of the chair unless the commission wants to override my decision. I'd like to hear once more from council, and then let's see if we can come to some kind of resolution.
Thank you, Chair Thompson. And thank you, Commissioner Dominguez. I think it's a very good point that this case was particularly difficult for you folks to review because of those issues that would be resolved by harmonizing the regulation statute. I can give you a path forward. The path forward today is to dismiss this case for lack of jurisdiction because no permitting action is being reviewed. That is unfortunate. I understand that Mr. Rose would oppose that, but I do think that he brought up a potential resolution to his client early on, which was that OCD issue some sort of compliance order, which I think resolves the particular issue with this case. And then moving forward, companies that are subject to permitting actions will still have that review potential from this commission, and then I'm sure the record will be created. What you're being asked to do today is simply to dismiss these cases for that. That would be the path forward. And I can write an order describing why the regulation is not invalid, but simply needs to be read in conjunction with and in harmony with your statute.
Okay. Thank you. So we've been working on this for going on 2 years, 18 months, something like that. We had a vote in October, and the vote did not stand because we did not have sufficient number of commissioners voting. So we've now got this petition to from Mr. Rose and the power companies to conclude that the OCD's permit required determination is not valid. I believe that's the request. My preference would be to move forward if we can today, which would require a motion. But we've heard this for so long. I'm not sure that we're gonna hear any new information if we defer to future ones. So with that, I'd ask if there's any commissioners that want to propose a path forward.
Commissioner Thompson, I'm sorry, Chair Thompson, how do we ensure that all of the parties have been represented by the argument prior to making a decision?
Well, the issue has been brought in these three cases, 55, 56, 57, and those parties are represented today. Ms. Mulcahy represents from others, although that's not part of the record until today. I don't believe.
And we would still, Commissioner Thompson, excuse me, Chair Thompson, request an opportunity to fully brief it. Although we've had discussion here today, there are other points that I also think the Commission should hear, and we would appreciate that opportunity.
Thank you.
And if I may, Chair Thompson, regarding that question, regarding the issue of all parties being notified, they'll get copies of the orders. Any case that this would affect will get copies of how this is going to be read moving forward. And then additionally, I want it noted, I didn't bring this up in this case, but this could have been brought up outside of any case. I could have brought this to your guys' attention just with the legal memo just amongst us, and it could have been discussed just amongst us, and could have been decided just amongst us, because how you guys apply your law is up to you ultimately. And yes, it will absolutely affect other parties. All of your laws and regulations affect other parties by necessity. But that doesn't mean that that should be the determinative factor of how you read it and how it is, how it reads by its plain language. Of course, all the other parties are going to have input because some of them will be more negatively affected than others. I would submit to you that that's not your consideration today.
Thank you. Mr. Blanchard.
Okay, well, Mr. Chairman, I see us having two. The issue actually is pretty simple, but not easy. I guess that's the way to look at it. It's all about the regulation that Commissioner Dominguez and Council were talking about, which is, and Mr. Rose, 3112B, which in addition to our normal appeal provision, which sort of follows with the act, it adds that if the Secretary determines that a discharger is not exempt from obtaining a discharge permit, and then there's other stuff here, then the discharger may appeal such determination by filing with the Commission notice of appeal to the Commission. Right? And the appeal must be, any action of the Commission must be in accordance with 7465, and then it'll list all these subsections that we've been talking about, O, P, Q, R, and S. So the question is this 3112B something that is actually in conflict with the statute, and therefore we cannot implement it, allow an appeal to the Commission under that section? The other option is to say, hey, it's our rule, 3112B, and we're going to stick with it. We think it's fine. What I think that Commissioner Dominguez has brought up the issue that this scenario in front of us may not be fine, and we may want to have additional development of a record by the constituent agency in order to make this a better decision by the Commission. So those are other, what we do going forward is sort of still up in the air if we decide to follow 3112B. So that's sort of where we're at. We decide this rule, which has been around forever, and you can tell how old the rule is because you look at the beginning of 3112, it references a discharge plan term that has been gotten rid of almost everywhere in the regs except perhaps there. they're all called discharge permits. Do we go with this old rule, or do we say this old rule has essentially been rendered in conflict with the current version of the statute? Okay.
Chair Thompson, if I may respectfully, Mr. Raymond, I disagree with the two options here. The rule can be read so harmonized with the statute. It just means that if a party wants to appeal secretary determination, they must do so in conjunction with a permitting action as outlined by the statute. That's all I can. I'm not asking you to invalidate your rule. I don't think it's invalid. I think it just requires a permitting action, which resolves all of the other issues that have occurred here, which is a lack of administrative record, a lack of public notice.
Okay, well then maybe what we are back on the second option, which says that 3112B is fine, but we need to figure out the process. Commissioner Dominguez started hinting at what's the process going forward to harmonize this then with the statute.
The process would be that the petitioner, in this case, Targa, engage in a permitting action, or that OCD issue a compliance order, that OCD engage in. And then this can come for review. That's it. It's actually very simple.
If I may add something to this discussion, I think that the rule already lays this out. And I think that Chair Thompson already lays this out. If you look at the express language of the rule, 3112A, if the secretary approves subject to condition, or disapproves a proposed discharge plan between, as Commissioner Ranker pointed out, renewal or modification, then an appeal therefrom shall be in accordance with the provisions of section 7465 N, O, and P. Okay? That would be consistent with how Ms. Bowen's reading. Now, if you would go to section B of 3112, it says if the secretary determines that a discharger is not exempt from obtaining a discharge permit, then the discharger may appeal such determination by filing with the commission secretary a notice of appeal in accordance with the provisions of O, P, Q, R, and S. What it doesn't say in B is because that means that this commission has interpreted permitting action to include something beyond just an application, denial, or approval with condition. That already comports with the statute. There's no need to twist yourselves around. And I would add, twisting yourself around now, from an outside perspective, looks like a post hoc rationalization to try and avoid voting on Mr. Rose's client issue. I understand that Ms. Bowen is now just counsel for the commission, but this is not the first time this issue has come up before the commission. In fact, I was involved in DP 1132, and it came up there. This is not a new issue. It certainly reads like this is a way in which the commission can avoid voting on this issue for Mr. Rose. Thank you.
Chair Thompson,
Briefly.
thank you. Subsection O references a permitting action. Permitting action is defined as what? So I think that our interpretation actually is very simple. Regardless of how this reads, I don't think should at all be a determination or a determinative factor in how you folks apply your laws. I think that's actually an inappropriate accusation to make, because this commission has comported itself with the utmost integrity and transparency throughout this entire process, and again, invited the parties in this case to make counter arguments on an issue that most other public bodies would never have invited them to do so. Typically, parties to a case that have a stake in the claim don't weigh in on how a public body interprets its regulations. and it's lost. I will leave it at this. I'm your counsel. It's my job to make sure that you're protected legally. That's it. That's my only stake in this claim. Certainly didn't enjoy bringing this up. It hasn't been the most. It's been an interesting intellectual debate, but it has been contentious. But I brought it up because I am confident in my interpretation of your statute. And it, to the, I'm sorry, I keep getting Mulcahy, I apologize. To her point, this issue keeps coming up because most people who read your statute at first glance say, wait a minute, this doesn't make sense. We're not sure that you can review this. It's not a permitting action. And I've had multiple people in my office read your statute, and we all agree. You only have review authority over a permitting action. It will continue to come up. And if an appeal comes up from this commission's decision regarding a case in which you've made a review decision, the Court of Appeals will probably bring it up. Because they can do that. Sui sponte. This issue will continue to plague this commission until it's put to rest, and I'm asking you to put it to rest now and to do it correctly. I understand that maybe this wasn't 30 years ago, wasn't contemplated as thoroughly, or whoever else was giving advice maybe didn't fully know all this, but I read it thoroughly, and I can tell you now this is the correct interpretation of the statute.
Comments from the commission. Mr. Brancard.
Commissioner, so Council Bowen, you said we can go with this rule by somehow turning this into a permitting action. How do you envision that? If I got your gist correct.
I'm just saying that the party that is asking for review of a permit determination must engage in some sort of prior to bringing it to the commission's review. As is outlined in your statute. The rule has to comply with the statute, not the other way around. The statute can't conform itself to, you're very well aware. And Mr. Rose brought up a potential resolution, which was that OCD could issue a compliance order, or OCD could engage or change their procedures to engage in a permitting action when they're issuing these decisions that allows for an administrative record, allows for public notice, allows for a hearing and evidence presentation. They can figure all that out. It's not up to this commission to have to figure all of that out. Your rules and your laws are very clear.
But OCD in this situation is not acting under its own rule. It's acting under the commission's rule. So it can't create its own rules.
No, and I'm not asking that they create their own rules. I am asking that the parties engage, whether that's an application for Mr. Rose's client for a permit and then a dispute over that application, request for a hearing, however it needs to play out below. I think this commission is getting hung up on. Because they have, in the past, created their procedures to comply with your guys' statute overall, right? Generally speaking, that's how they operate. They've created their procedures to comply with the statutory language. And all I'm asking is that they do that now too. And it's more than feasible.
And Mr. Chair, let me weigh in if it's allowed. One, we appreciate the opportunity to comment on this. And Ms. Owen pointed out, normally you'd have this discussion with council, but without the parties being allowed to opine. So we appreciate that opportunity. But I think basically, and I think Commissioner Brainerd's right, it's a fairly simple question. Does the term permitting action in O refer to just those actions in N, or is it meant to be broader than those actions in N? Our argument is it's meant to be broader. If the legislature meant it to be limited to only the actions in N, knew how to do that, it could certainly have done that. And we cited two cases for you to review. One, both Court of Appeals cases, not dealing with the Water Quality Act, specifically one dealing with the Radiation Protection Act, which construed the term licensing action in terms of a review provision to include grant or denial of exemptions. And so we think that's the proper way to read the statute. And we've also pointed out that in citizen action, the legislature, the courts have construed the Hazardous Waste Act and repealed provisions for final actions to include certain determinations beyond just the basic permitting, the grant denial or grant subject to conditions or termination of permit. So we think the Court of Appeals cases gives you guidance that you can construe the term licensing action broader than the limited actions referenced in that. It's really up to you to decide how you construe your statute, and ultimately the court will decide whether that construction is correct.
Thank you. Mr. Armstrong?
Do you notice that, Mr. Chairman, you noticed I might have something to say. I was looking at the definitions, I was looking at the regulations and then back, of course. I mean, at this point, I'm inclined to look to the existing regulation. Because I feel like that's where the commission, not me on the commission as a body, has made a policy choice. So I'm looking at the existing regulation and the definition within the regulations of permitting action. And I see that it refers to 74650 and not 7465N. And while I think it's reasonable and maybe even likely that the legislative intent of putting N before O and listing potential actions and then discussing permitting actions would be limited to that list, the legislature didn't provide a definition. And the commission previously has decided to point to O as the definition of permitting action and not N. Again, I think that indicates a policy choice of being a little bit broader than what N lists. I don't know if the commission today would agree with that policy choice, but I'm persuaded by Ms. Mulcahy's point earlier that it is the regulation, and I feel bound to that regulation.
Vice Chair, may I ask a question?
Absolutely.
In reading O, a person who participated in a permitting action, how then would the commission define a permitting action? If not for reading in the section immediately preceding, how then should permitting action be defined? If we open up this interpretation, that is a huge can of worms. If we agree that permitting action can constitute whatever the constituent agency or the parties want it to be, then you folks are going to be reviewing a whole lot of issues that the legislator did not intend for you to have to review.
Okay, I'm looking at the commission and I am not seeing any motion forward. Again, it's my preference would be that we would take action today and resolve this. If we don't, what would the commission like to do to hear this further? It's sort of inconceivable to me that we would hear any new testimony that would be substantially different than what we've already heard.
Chair Thompson, I guess from my perspective as a business owner, I cannot reconcile the fact that you would require a company to permit something that they don't believe they are required to permit, or the only other alternative would be to open them up for liability of a compliance order. I mean, really makes me uncomfortable to think that you have to break a rule in order to get a proper hearing and then be subject to potential fees or fines or whatever if you get if you don't win your case. And so that's just my perspective as a business owner. I don't see a path forward on the correct liability for a company to continue forward in this matter. So it makes me nervous. I want to make sure that we're hearing all the arguments and that, before I can make a decision. And maybe there wouldn't be new arguments to this case, but I don't think it isn't without reason to make sure that other parties in this, section, docket 2312 and 2313, have we heard from those companies appropriately? That would be just my caution.
Mr. Chair, if I may, just going back to Council Bowen's question, to me, that took me a second to think about it. What do we do with the language of notice as a person participating in the permitting action? If permitting action isn't clearly limited, those actions in end. Fair point. And I think it's the assumption of the commission that process would actually allow people to participate in it. That it wouldn't just be, and I'm new to the commission. I'm not clear exactly how it all played out at OC or fix here. If it's just communication between ARGA and OCD, or if there is a public process where any person who is able to participate and then preserve their right to appeal to this commission. So, fair question, Council. And if that's not in place, even if we can read permitting action more broadly, in terms of just like a straight definition, we're not meeting the statutory requirement of the person being able to participate. I had some clarity.
I need either a motion to accept or deny the petition, or a suggested strategy that we can figure out on how we will address this at a future meeting.
Mr. Chair, just one point. I think that what you have in front of you is the question of whether you entertain the petition now, whether the petition should be granted or not, because under the Open Meetings Act, you haven't given notice of the Commission's consideration of the final decision on the petition. So I'll leave it up to Ms. Bowen, but I think that's beyond the scope of what has to do.
Yes.
Yeah.
Thank you. Look to the left and look to the right.
At this point, what we're being asked by the council is to dismiss WQCC 22-55-56 and 57 for the lack of jurisdiction. And I make that motion at this point.
Second.
Yes, it's just.
Thank you for the motion. Are you ready to vote? Is there any discussion?
Mr. Chair,
Just, and forgive me, I'm also fairly new here and I don't know all of the legalities behind it, but to say that we don't have the ability to do this, what complications does this set as a precedent for us into the future? Or are we just saying here and now and limiting it just to these particular cases? I worry with the phrase is that it could extrapolate to further issues in the future.
Right.
That's a good question. The issue is simply that petitioners who want to have a review of the Secretary determination will have some sort of limiting action to have that. It's pretty simple for them, and we can make sure that all of the constituent agencies are notified of this, and that all the companies that might bring these petitions in front of you are notified so they understand what the requirements are. What that will do is that will allow for administrative record to be created before it comes to you. We don't need a remand. It'll allow for public notice, public comment, all of the standard procedural due process rights that accompany those permitting actions that are already clearly outlined in the rules and regulations. That's it.
Thank you. Again, I ask, are you ready to vote?
Yes.
Okay, so the motion is to dismiss WQCC 22-55, -56, and -57 for lack of jurisdiction. Is that an accurate recap? Madai, would you please call the roll?
Yes. Vice Chair Armstrong, how do you vote?
Yes.
Commissioner Brinkford,
Yes, and I'll have to explain my vote.
Commissioner Candelaria, absent. Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
No.
Commissioner Palladino,
Yes.
Commissioner Rosato,
I'm vacillating on this one. No.
Chair Thompson,
Yes.
Commissioner Mejia,
Yes.
Commissioner Assembly,
Yes.
have 8 yes. 2 no.
Okay. So that's been resolved. Commissioner Blanchard, would you, reluctantly, I'm offering you the opportunity to explain.
My concern is that the process is stopped, that the process under 3112B does not comport with the statutory process. Okay? I'm, I guess, a little less concerned about the definition. I do think the commission has some flexibility to sort of expand on the language of the statute because there is no definition of permitting action in the language of the statute. So I do think we could create a process by regulation for these types of actions, but we don't have one. Right now we have a direct action that really doesn't comport with the statutory process for hearing, notice, et cetera, by the agency below.
Commissioner,
Go ahead and say it. Reluctantly,
very
yield to Commissioner Breakhurst's point. And he brings up a valid point. Things are kind of squishy there. and whether it needs to be a modification of the rule to fully address Part O of the statute, or permitting action, or a process for an exemption is addressed. The commission doesn't start rulemaking processes. Constituent agencies or parties bring rulemakings before the commission all the time. And if OCD or Environment Department or whoever feels there's a need to adjust a rule, by all means, it's their prerogative to bring the rulemaking forward to the commission. And if that helps clarify some of the issues that we got stuck in that hamster wheel for 2 years on, well then, so be it. That cleans up something where it's clear for everyone involved. So I'm just throwing that out there, that in the long run is an alternative to have a defined process. Thank you, Mr. Chair.
Thank you, Mr. Dominguez. Okay, so we're done with this. I'd like to move on to agenda item number 9, which is an update on the lawsuit filed by the NMED versus the Water Quality Control Commission regarding TMDs.
So I want to, Chair Thompson, if I may, I'm going to go ahead with this presentation. And before I do, I'm going to open up some question whether or not you want to go into closed session. This is contemplating pending litigation. So pursuant to the Open Meetings Act, you're allowed to go into closed session to discuss this. It doesn't have to be. However, I'm going to give just a brief overview. I'm going to go into it at length, but I wanted to leave it up to you folks so they're not. And just a reminder, this is a Court of Appeals case involving the Environment Department versus this commission. So you are direct.
My preference is let's hear this in open session. This is just an update. We want to discuss any strategies that
Okay. So the case is largely regarding the definition of TMDLs and whether or not they qualify as a rule or regulation, and would therefore need a rulemaking process in order for them to. At the time that this case was brought, there was a Court of Appeals case called Rio Hondo, where the Court of Appeals determined that a TMDL was a rule or a regulation, a needed rule. The Environment Department argued that it is not. And so Commission Counsel at the time premised his argument on the basis of that Rio Hondo case, saying it is a rule or regulation and needs rulemaking is going to be implemented. Last session, our legislature passed HB 142, which is somewhat narrow in that it's only applicable to the San Juan generating facility, but it also has a section in there that says the independent restoration and remediation plan shall not be considered a rule or a standard for purposes of the Water Quality Act, but shall be considered a planning document. Planning documents are not rules or standards under the Water Quality Act. So based upon a plain reading of HB 142, to conflict with the Court of Appeals determination in Rio Hondo. HB 142 went into effect, I believe, in July. So you're now operating under the authority of HB 142. I have spoken with NMED counsel on this Court of Appeals case. I believe it's still here. Thank you for waiting this long. And we've discussed a potential resolution moving forward. It is my interpretation that HB 142 invalidates the Commission's position on this case that was originally taken prior to the passage of HB 142. So I'm not saying that the position at the time was incorrect, but I do think it is incorrect.
Ms. Bowman, HB 142, and I haven't looked at it closely, but it did not specifically make an amendment to the Water Quality Act. Is that a fair statement?
That is a fair statement. I think what it did was it clarified what a TMDL is within the meaning of the Water Quality Act, based on what our legislature wanted to be. Now, would it have been nice if they had simply amended the Water Quality Act? Yes. I'm not going to speculate as to what they were thinking or what they weren't thinking, but I would also note that the Rio Hondo decision, while our code is very smart, they don't always get it right. And the Water Quality Act is very convoluted, and the subject matter is difficult. And so I think that in the long run, though, that this resolves that question, and I think resolves that case. And actually probably isn't the best, it's the best for you folks, because considering TMDLs to be a rule or regulation will make matters very difficult. That being said, I'm going to continue to have discussions with NMED, their council, regarding the best plan to move forward. We've discussed some preliminary ideas. Nothing is set in stone yet, but I don't want to discuss it necessarily today. But I'm happy to provide a legal memo to you folks once we come up with a plan to get your input. If anyone has any further about it, to provide either objection or support. Because I do represent you, so. If you don't agree with how I would suggest we proceed, then I'm happy to hear that. But that'll be at a later date. I just wanted to provide you this update because I know that Mr. Frank has been working. So, I wanted to provide what would be my office's interpretation of HB 142 and how it applies to Water Quality Act.
Thank you.
That's this year's House Bill 142.
It was last year.
Oh.
So it went into effect in July.
Okay.
Yeah, that was nice.
One thing, Ken and I have discussed this just briefly. One thing that is a little bit concerning to me is that it specifically states that planning documents are not rules or standards under the Water Quality Act. That's the only place in the legislation that refers to the Water Quality Act. And it seems to me it would be a lot more straightforward if the Environment Department proposed language that specifically amended the Water Quality Act, identified planning documents as not having regulatory status. So I would offer that as a suggestion. It would be clear and remove any ambiguity. Mr. Brancard.
Yeah, just maybe council forgot to mention this, but the next subsection in the new statute says defines planning documents. It says that planning documents may include remediation plans, restoration plans, and total maximum daily loads. So TMDL is specifically mentioned in this statute. And really, the case, the issue in the Rio Hondo case was just TMDL. It wasn't planning documents in general. So like the integrated plan that we just approved today, come on, it's not a rule. It's just a document to be submitted to EPA. So I think it's fine. I mean, I think if we need to say something in regard to our decision formally that we made back a year and a half ago, that's fine. Whatever it takes. The Environment Department, I think, needs to dismiss this lawsuit and needs to start bringing these cases before, start bringing the TMDLs before us for approval.
Thank you, Commissioner Bernhardt, and thank you for noting that section. I apologize, I didn't mean to bring that up. But yeah, it's pretty clear that HB 1 TMDLs are not rules and regulations. As for a path forward with the case itself, I would like a decision from the Court of Appeals in conformity with HB 2. I think that would help with the case law moving forward, for them to read this and also provide either a confirmation or counter arguments as to why we're wrong. But I think that could help everything moving forward and kind of put this to rest. So my plan was to file something in front of the Court of Appeals and allow them to make that decision. I've spoken with the MD about whether that would provide significant complications with their TMDL approvals, and it would be okay to wait for the Court of Appeals to make its decision. And so that was kind of my thinking moving forward.
Any other, Mr. Chair, the Court of Appeals is painful as well. Yes. I mean, we could be waiting a year or two even to react to something as simple as your proposal. So, as we heard earlier today, there is sort of a backlog of these TMDLs out there that could be coming to us. My feeling is the sooner the better.
Yes, I agree. Commissioner Dominguez? Okay. Any other questions or comments? Does NMED wish to comment on this? Please do. Your record, please, teacher.
Thank you, Chair Thompson, Crystal Weatherly here with the Environment Department. I would like to remind or maybe inform the Commission that the Court of Appeals has submitted this case to a panel of judges, which was only a few days ago. So I do believe that it's moving along. That said, I agree with Commissioner Reichert that moving along in the Court of Appeals, is deadly. But I do, the department does agree with Ms. Bowen in a decision from the Court of Appeals would clarify this not only for ABD but for agencies.
One question. Thank you. One question. What clarity is that we're lacking from House Bill 142 that we're seeking from a Court of Appeals decision?
Is that a question for me?
For either council.
Would you like me to?
Yeah.
Okay. I think that as the Commission, well, let me take a step back. For NED, it's clear to the department what a TMDL is not, and what we have now is a memorandum of opinion that says that a TMDL is a rule for purposes of jurisdiction. That is in the station, and now we have a statute that correct that and to have the clarity from the Court of Appeals to acknowledge that new statute would clarify what a TMDL is. I'm not sure I articulated that very clearly.
And if I may, just to piggyback off of that, I think that the only question for you is it applicable? Because AB 142 was written specifically to the San Juan Generating Facility. Now, I think it is applicable broadly. I think it's clear from the language. I think NMED agrees with me, and I don't want to speak from Weatherly, but it sounds like they are. But that might be the only hiccup in applying this broadly, and having that Court of Appeals opinion would put that to rest.
Thank you both. Good.
Okay, let's move on. That requires no action from us. Agenda item 10 is to set our next meeting date and upcoming commission matters. Ms. Jones, do we have any matters that are likely to come before the commission in April?
I don't have anything definitive yet. Doesn't mean that something will trickle down at next meeting, that it would be April 8th.
May. April or May?
I'm sorry, the 9th. Excuse me. I'm looking at the wrong day on my calendar.
And then my recollection in May is we've got a pretty full agenda. I think we're going to hear it well. We've got one topic that I know of, and that is the water reuse regulations.
Right.
Which my fear is that's going to be.
That is WGCC 2384, and we are scheduled to start that on Monday the 13th.
Yes. Okay, and we've got several days set aside. Okay. Any other business for the commission? If there are not, I declare we're adjourned. Thank you.